Hi, everyone. Thanks for joining us. We'll give it just a minute to let folks come into the webinar, and then we'll get started. Great. Hi, everyone. Again, just give it another second to let everyone get brought into the webinar room. But thank you for joining us. We'll get started in just a minute. Great. Well, it looks like numbers are slowing down a little. So in the interest of time, I'll go ahead and kick us off. Good afternoon, everyone. Thank you for joining us for today's Lunch and Learn. My name is Louise Bedsworth. I'm Executive Director of the Center for Law, Energy, and Environment at Berkeley's School of Law. The Center of Law, Energy, and Environment sits within the law school to build connections between experts within the law school and really across the broader campus to policymakers and practitioners to solve our most pressing environmental issues. Through our Lunch and Learn series, which this is a part of, we host conversations on a range of environmental topics, including unpacking complex and pressing environmental topics and to present innovative new research findings. Our Lunch and Learn series is made possible through our partners, Wilson Sonsini, Orrick, and Hanson Bridgett. So thank you very much for their support. Today, we have a terrific set of experts from Berkeley Law to help us understand one of the most significant environmental law cases of our day, last Thursday's Supreme Court decision in the West Virginia versus US EPA case. In addition, they're going to share more about the case and then discuss what it means for the future of climate policy. So with that, I will introduce our panelists and moderators for today's session. Dan Farber is the Sato Professor of Law and the faculty director for CLEE. He is one of the most respected experts in environmental and natural resources law. He's a prolific writer, authoring numerous books and articles, and he's a regular contributor to Legal Planet, our blog, where you can see a series of recent posts on the West Virginia versus EPA case and its implications. Our second panelist is Sharon Jacobs, who just joined the Berkeley Law faculty as of July 1st, and we're thrilled to have her here. Until last week, she was an associate professor at the University of Colorado in Boulder. Her research focuses on the impact of regulatory structure and process on policy outcomes in energy and environmental law at the federal and state levels. So we're thrilled to have Sharon joining us today and more broadly at Berkeley. And finally, our moderator is Ted Lamm. Ted is a senior research fellow in our climate program at CLEE, and he leads work in a number of areas, including climate risk and resilience, building decarbonization, and transportation. Ted filed, along with Sean Hecht, our colleague at the Emmett Institute at UCLA, an amicus brief in the Supreme Court in the West Virginia versus EPA in defense of EPA's authority to robustly regulate greenhouse gas emissions. And so with that, I think we have a terrific group of panelists for this discussion. I will turn it over to Ted to lead off.
Great. Thank you so much, Louise, and thank you all for joining us today. I'm sorry it's under these unfortunate circumstances, but it's a pleasure to have you to discuss the implications of last week's decision with Dan and Sharon. So as you all are certainly aware, last week the Supreme Court issued a ruling in West Virginia versus EPA, which limited the EPA's ability to regulate greenhouse gas emissions in order to address climate change. Now, I'm joined today by two far more expert colleagues, Dan and Sharon, who will discuss the legal context and the key elements of the opinion. So I'm not going to go into too much detail now, but I will provide just a bit of background before turning it over to them. So the case involved the Clean Power Plan, which was the Obama administration regulation for greenhouse gas emissions from existing power plants. These sources cause about 1/4 to 1/3 of all US greenhouse gas emissions. The plan, very basically speaking, the plan set sectoral emission reduction targets for each state based on what could be achieved through a combination of strategies, including shifting from natural gas and coal power plants to renewable energy or non-emitting sources. It then directed those states to develop plans to achieve the targets. This was all based on a provision of the Clean Air Act, Section 111D, which requires the EPA to set standards for existing stationary sources. Now, the plan never actually went into effect due to some convoluted multi-year litigation, which Dan will review briefly. But the court took an unprecedented step last fall and agreed to hear an appeal from a group of conservative states and coal companies after a lower court essentially upheld the Obama administration approach. And last week, in the decision in the case, the court ruled essentially that the Clean Power Plan exceeded EPA's authority under this provision of the Clean Air Act, based primarily on a somewhat newly announced and novel major questions doctrine, which Dan and Sharon will both explain in detail. In short, the court stated that EPA was limited to regulating individual facilities rather than the sector in a comprehensive approach. Now, the ruling has a limited immediate impact since the plan never actually became effective, but it does have major implications for federal climate regulation, environmental regulation under the originating statutes from the 70s and 80s, and agency regulation across government more broadly under this conservative court. Now, all of this has been a huge oversimplification, but of course, that's why Dan and Sharon are here. So I'll turn things over to them for introductory remarks, and then we'll move to a discussion and Q&A. And we will start with Dan with some background on the legal context of the case and first thoughts on the implications of the ruling. Dan?
Thanks. When EPA was given authority to regulate greenhouse gases as a result of a 2007 Supreme Court decision, it had a bit of a dilemma. The Clean Air Act provisions about new pollution sources and new vehicles is pretty easy to apply to greenhouse gases, but it's harder to adapt the requirements for existing sources. They're designed with urban air pollution in mind, and they don't fit terribly well with the very different and difficult problem of climate change. That meant that EPA had to do a deep dive into all 300 pages or so of the Clean Air Act and try to find provisions that would work. And as Ted said, they came up with Section 111D as the solution. It's a provision that has rarely been used in the past and generally not for high-profile regulations. But the way it works is that EPA is supposed to determine the best system for controlling emissions. And then the states are supposed to put this into effect by issuing plans that reflect that best system. And one of the key issues is, what is the system? Is the system something that takes place at a single power plant? Could it include nationwide cap and trade? Could it include various things in the middle? That was the core legal issue in the case. The Obama EPA came up with the Clean Power Plan, which, roughly speaking, treats a state's entire electric grid as if it were like a single source, and then it requires the state to ramp down emissions from the grid as a whole. And the way of doing that is to cut the use of coal and gas and increase the use of renewables. There was then a complicated set of events. There was the unprecedented stay of the Clean Power Plan by the Supreme Court, and that was a less conservative court than we have now. Then the Trump administration came along. They tried to repeal the plan and came up with a plan of their own. The DC Circuit then overturned the Trump administration's plan. And then, as Ted says, very surprisingly, the Supreme Court decided to jump into the case. The utilities didn't really want it or didn't think there was any chance of getting the Supreme Court to jump in. It was really only some coal industry and related interests that were pursuing the case. So let's fast forward to the end of June when the court struck down the Clean Power Plan. The court described the plan in a way that at least made it sound fairly radical. It argued that EPA was abusing its powers by using a forgotten statutory provision and doing it to leverage an unprecedented leap into a new area of regulation that is running the entire electric power sector. I don't think that's really a very accurate description of the Clean Power Plan, but at least that's the way the majority of the court saw things. Because of the radical nature of what EPA was doing, the court said that this presented a, quote, major question. And under what's called the major question doctrine, that requires a clear statement of authority from Congress. The court didn't see anything clear enough in the statute. So if you're writing a regulation, obviously one thing you don't want is to have it be classified as a major question. I'm going to talk really briefly about the implications for climate change, regulation, and about the effect of the major question doctrine, but I will try to keep each of those to about a minute. Clearly, EPA can't do anything like the Clean Power Plan again. But the court didn't quite embrace Trump's ultra-narrow view of EPA's powers either. So there seems to be some middle ground, not clear how big it is. One possible EPA response would be to require coal-fired plants to use natural gas or biomass along with the coal. And there's some studies that show that this could actually cut coal emissions in half and wouldn't cost very much money. What about the more general implications? It really kind of depends, I think, on sort of where you saw things before this decision. This decision was the first to use the phrase major question doctrine, at least in a majority opinion, but it wasn't the first to apply the doctrine. And I see Chief Justice Roberts' decision for the court as potentially narrowing the major question doctrine compared to other views like that of Justice Gorsuch. So the way I look at it, and the way I hope that the majority will look at it in the future, is that the court's message to agencies was stay in your lane, not put on the brakes. And now I'm really looking forward to find out Sharon's perspective on the case.
Great, thank you so much, Dan. Just to point out one quick item that you highlighted in your remarks before we flip over to Sharon, which is the court's interpretation of what authority was handed over in the first place, and noted in the dissent that the court did not actually spend that much time even dissecting the language of the statute itself, and did not look to the language that set out EPA's broad authority to address air pollution problems, but rather looked much more narrowly at the specific provision in question. A little more detail perhaps than we need at this moment, but something for those in the audience to understand as Sharon talks a little more about the major questions doctrine and the specific implications of the Section 111D analysis. Sharon?
Great, well, thanks, Ted and Dan. It's great to be here with you today in my first CLEE event, and I'm delighted to be joining the faculty here at Berkeley Law. As you can see, I am here, but my books are not yet here, so I apologize for the empty bookshelves behind me since I'm just moving in. I thought I would start by just agreeing with some of Dan's comments and saying that, the opinion was not quite as bad, I think, as some in the environmental community had expected it to be. For those of you that remember and enjoyed David Letterman's top 10 list on his late night show, I thought I would do a sort of a top 5 list of my own. And these are top 5 things that the court didn't do in this case that some expected that it might. So I'll just go through these quickly. The first of which is bad news for the environmental community, but the remaining 4 are good news. So the first thing the court didn't do in this case is dismiss the case as moot, right? After all, the challenge here was to a rule, the Clean Power Plan, that never went into effect, and which the Biden EPA said it had no intention of putting into effect. So there was some possibility the case would just be dismissed outright. That didn't happen. The second thing that the court didn't do in this case is it did not uninter the non-delegation doctrine. I think there were sort of hints of this in Justice Gorsuch's concurrence, the idea that this might be the kind of case where the court would say, actually, there are some things that are so important and so major and look so much like legislating that Congress simply can't delegate them to agencies, full stop. So that didn't happen. The third thing that the court didn't do in this case is it did not adopt, as Dan said, the most restrictive version possible of the major questions doctrine. We can get into that in some of the Q&A if there's interest, and I'll talk a little bit more about that in a minute. The fourth thing is that it didn't suggest anywhere that Massachusetts versus EPA, the landmark 2007 case that gave EPA authority or condoned EPA's authority to regulate greenhouse gases under the AIR Act, was on the chopping block. There was no suggestion of that, and I think we may talk about that a bit more as well. And then finally, this opinion did not preclude EPA, as Dan said, from regulating existing power plants under 111D. It just limited the one way in which EPA had sought to do that. So let me pick up on that last thread for just a minute and talk about why 111D authority is so important when it comes to curbing greenhouse gas pollution. It's important first, I think, because existing power plants produce so much of the carbon pollution in the country. And then secondly, it's important because it's one of the best tools that Congress gave EPA in the Clean Air Act to regulate that pollution. So, first on the significance, we have seen carbon emissions from power plants dropping steadily from about 2005 overall, even though there was a little bit of an uptick as we started to emerge from the pandemic in 2021. But overall, we see sectoral emissions down about 20% since 1990. Nevertheless, right, power plants in the US still make up about a quarter of all of our greenhouse gas emissions, as the dissent pointed out in this case. That's nearly 3 times the emissions of the next 10 stationary source categories combined. So that makes this a big target for EPA in trying to reduce carbon pollution from stationary sources. And of the mix of power plants in this country, about 60% are still fossil fuel plants. And so even though coal only makes up about 20% of that, they account for about 50% of carbon emissions. So reducing greenhouse gas emissions from power plants remains crucial to achieving any kind of national climate goal, as the dissent again recognized. So that's the first reason that this target is important. The second reason this provision is important is because 111D, as I said, is one of the better tools EPA has under the Clean Power Plan, not the only tool, right, which we can talk about, one of the better tools it has to address emissions from existing power plants. Specifically, the Clean Air Act's drafters were not excessively concerned with emissions from existing stationary sources. They grandfathered in a lot of those sources. The most stringent regulations are targeted at new facilities. And that's primarily because the drafters, I think, thought and expected that most of the power plants existing at that time, right, in the 70s, would be long gone by now, that they had a useful life of about 30 years. So by around the turn of the century, we wouldn't have existing power plants anymore, or at least not many. But power plant operators have found truly ingenious ways of keeping those plants running. The average life of a coal plant today is about 45 years, or the average age rather of a coal plant is about 45 years. So these existing coal plants remain a major source of carbon pollution, and the Clean Air Act doesn't give EPA a lot of tools to deal with them. But 111D is one of those tools. So Dan offered some helpful background on that section, and I won't go into that again here. We can come back to the debates about the statutory language and precisely what it authorizes. But the bottom line, right, is that the majority opinion held that capping carbon emissions at a level that will force a nationwide transition away from the use of coal to generate electricity is a decision of such magnitude and consequence that it rests with Congress itself, or an agency acting pursuant to a clear delegation from that representative body. It did not find such a clear delegation here to do what EPA did, which is to base its emissions reductions on this idea of shifting generation away from coal plants to natural gas plants to renewable energy plants. So there are, a number of major implications that we can talk about today from this decision. In terms of the practical impact on coal-fired power plants, I actually don't think the impact of the decision is going to be too great. And that's because coal plants, the writing is on the wall. They're sort of on the way out. And that's because of economic pressures, not because of anything EPA is doing. Coal plants are having an increasingly difficult time competing with new natural gas plants, competing with wind and solar just on the economics, right? Just on the costs. And so all of the new capacity additions we're seeing in the power space are renewable or they're natural gas. We're not seeing new coal plants go in, and I don't necessarily see that changing. So over the longer term, I think the trajectory is going to remain largely the same. We're going to see about half of US coal plant capacity come offline by the end of the decade by some estimates. So even though these power plants have been around for a long time, they're not going to be around forever. And again, that's because of the economics and also because of the vibrant array of state level policies that we've seen in this space. And we can talk about those a bit more as well. So the impacts that I think we'll see are more immediate in terms of what remains for EPA, other agencies in the federal government, and state and local governments to do when it comes to regulating and targeting these specific emissions from power plants. I think, as Dan mentioned, there are still options for EPA under 111D. There are options under other sections of the Clean Air Act, and we can talk about some of those. And there are options for other agencies under other statutes. We'll also, if we can get into, if we like, some of the options for individuals bringing lawsuits, right, themselves, and for some of the state level policies. But maybe I'll just wrap up my, my introductory remarks by saying the impact of this major questions doctrine, the doctrine itself is not new, although there's an interesting little back and forth between the majority and Justice Kagan's dissent about whether or not it exists, right, and whether the majority is announcing something new here. And Justice Kagan says, we've never called the thing by its name before. And Justice Roberts seems very eager to call the thing by its name and really put down a marker here. That doctrine could have far-reaching implications for other agencies and implications in the energy sector. And I'll just flag one example, which is that the Federal Energy Regulatory Commission is going to be doing some people might say relatively transformative things in wholesale energy markets in the coming years. It issued a policy statement last year talking about how it would assess the incorporation of carbon pricing into wholesale energy markets. That is, states, a number of states have policies putting a price on carbon that affects the price at which their generation assets can bid into these wholesale energy markets. Does FERC have the authority to review those wholesale market rules that incorporate carbon pricing and take that pricing into account and approve those plans? That is going to be a question that may run afoul of the major questions doctrine in the sense that FERC's authority for doing this is the just and reasonable standard under the Federal Power Act. By no means a backwater, but a very broad general provision. And this is, some might say, quite a newish transformative responsibility to think about carbon pricing in energy markets. So we may see, in fact, we'll likely see challenges to FERC's authority there. It's just one example of the myriad ways in which the major questions doctrine will affect agency authority.
Great. Thank you so much, Sharon, and thank you both for your excellent introductory remarks. I'm going to kick this off with a few questions of my own, and then we would love it if members of the audience could begin to bring their own questions via the Q&A or the chat, and we will get to those after about 10 minutes of moderated Q&A, using my own privilege there. And perhaps maybe we can pick up on the last point you raised, Sharon, which is the nuances of the newly announced major questions doctrine. And of course, there is some irony in the court referring to and plucking from a slim precedential history, this doctrine, in a case where it's pointing out that the agency it's discussing has not regulated this way under a 50-year-old statute. There's a bit of discordance there, perhaps. But could we maybe talk for a second, and maybe Sharon, you can kick it off with a little bit of discussion of how Chief Justice Roberts, in his opinion for the court, framed the doctrine versus the slightly more muscular version that Justice Gorsuch proposed in his concurring opinion, and if you can highlight some of the differences in application that we might see there.
Yeah, sure. So I have my own take on what the Chief Justice did in the majority opinion that I'll offer, and it's based on Justice Scalia's opinion in an earlier case, Whitman versus American Trucking, where Justice Scalia talked about Congress not hiding elephants in mouse holes. This is a phrase that gets repeated a lot in the context of the major questions doctrine. And the idea basically being, right, that if Congress wants to convey anything substantial to an agency, it will do so clearly. So I think Chief Justice Roberts is sort of following that rubric in the way he sets out the major questions doctrine, that he wants us to look at two things. One is the statutory provision at issue a mouse hole. And so he makes much of the fact that here, Section 111D is this little used, little known provision of the Clean Air Act, right? That it's only been invoked 5 or 6 times and not to be transformative things. That to Justice Roberts is a red flag because that's a mouse hole. That's not someplace where we would expect, according to the Chief Justice, to find transformative authority the agency can exercise. So to me, that's step one of the Chief Justice's version of the major questions doctrine. Step two is, do we have an elephant? Right. So what is the nature of the power here that the agency is asserting? And a key difference between the Chief Justice's approach and Justice Gorsuch's approach in the concurrence is that the Chief Justice, as Dan said, is looking at factors like, is this an unprecedented assertion of authority in the sense that there seems to be a real mismatch between what the agency is tasked with doing as a general matter, where its expertise lies, and the power that it's asserting in this case. So they look to history, right? The Chief Justice looks to history to see if the agency has asserted power like this in the past. That's one of the considerations. And also looks sort of more generally at this, like, is there an expertise matchup, right? Is the agency staying in its lane? Also looks at some of the factors Justice Gorsuch considers, like economic and political significance and inconsistency with congressional action. But I would say that the sort of the main thrust of this truly unprecedented? Is it something that makes you sit up and go, what? Why is the agency doing this, right? Why is this agency taking this action? Contrast that, I think, with Justice Gorsuch's approach in the concurrence, which seems to more or less gloss over the mouse hole step, at least in my read of this, and looks instead at the nature of what the agency is doing full stop, right? And talks about factors like, is this politically significant? Is there ongoing and vigorous debate about this type of issue, say climate, right? Or the energy mix in the country? And if so, that's a big enough issue for Justice Gorsuch to justify invoking the major questions doctrine. Is this an action that would cost billions of dollars? Is another point that Justice Gorsuch brings up. And that could be a whole range of agency actions that would not fall within the major questions doctrine as articulated by Chief Justice Roberts. So I think Justice Gorsuch's version here, which did not garner majority support, is much more sweeping, but I'd be curious to hear Dan's thoughts.
Yeah, I agree with all of that. And I'm not sure I could have said it quite as concisely and clearly. I think Gorsuch's version is a lot broader and a lot scarier because essentially, the way I translate it is, operationally, is if an issue gets enough airtime on Fox, it's a major question. And I don't really like that as the idea of a legal test. So I do think, and I think it seems pretty clear, at least from what I've been hearing, that Kavanaugh really shares this elephant in a mouse hole perspective on the doctrine. I think that's a good, I mean, it's still in some ways a very problematic doctrine, but I think it's one that is threatening to new initiatives, but not threatening in the same way to a broad range of kind of well understood agency regulations. I mean, there are a lot of things that cost billions, national air quality standards, for example, are really expensive. I don't know if they get on Fox, but of course that would be easy to change. So I think that would be very scary. And I think it's also one other thing I would point out is that only one other justice joined Gorsuch, Justice Alito. And I think that's maybe a sign that at least some of the others are maybe willing to line up with Kavanaugh and Roberts on the meaning of this doctrine. I hope so anyway.
Maybe I'll just add one other thought that was prompted by Dan's comment just now, which is that even if there are only two justices, right, that are taking this more expansive view of the major questions doctrine right now, the doctrine itself remains relatively ill-defined. So that in future cases, even if there are only two votes for this more expansive version right now, all bets are still off by my read in terms of what the exact contours of the doctrine are. I mean, as someone who has to teach this in administrative law this year, you know, it's going to be hard to pin down exactly what this doctrine looks like. Although I am going to steal Dan's, you know, Fox News capsule summary.
I like the idea of announcing that the court has adopted a 4-factor test, and then, you know, trying to sell that to everybody as kind of the limitations of the doctrine. But as you say, we'll have to see.
So moving to some of the questions that the audience is excellently proposing that align with the questions I wanted to ask, maybe we can move to the most major question of all, which is the impact of the case on Mass v. EPA. And you both briefly mentioned the fact that the opinion does not at all expressly discuss anything to do with Mass v. EPA. I will note that as far as I recall, none of the litigants actually raised any challenge in any fashion to Mass v. EPA. But could we maybe just talk for a moment about how that ruling originated and what if any implications there could be for the agencies and the federal government's core ability to regulate greenhouse gas emissions full stop under potential extensions of this ruling?
As to how it came to be, there's a great book by Richard Lazarus called The Rule of Five that really dives into that. And it's a fascinating story. But basically, it was a lawsuit against the Bush EPA to force them to consider regulating greenhouse gases. And the Supreme Court agreed with the challenge and basically told the EPA, you have to tell us whether greenhouse gases endanger human health or welfare. And the answer to that one was a foregone conclusion. And then if they do, you have to regulate. So that was a big step forward. I think this opinion only solidifies Massachusetts versus EPA. In previous cases involving climate change, generally somebody or another like Alito would file a concurring opinion saying Mass v. EPA should be overruled. And there's nothing like that in this case. And I think the court's opinion would be incomprehensible if except for an assumption that the Clean Act in general and 111D in particular do apply.
I mostly agree with that. I think, you know, the risk to an opinion like Massachusetts versus EPA comes not from anything we see in this case, but in this sort of broader sense we're getting from the court this term, that it is willing to reconsider what we all would think to be long established decisions based on, you know, the Dobbs test now for overturning precedent, or, you know, how, I guess it didn't originate with Dobbs, right? But how bad or wrong is the original decision? And then what are the reliance interests involved? And we certainly don't see the writing on the wall in this particular case. But I think that one could use the major questions doctrine to rethink Massachusetts versus EPA, which relied to a significant extent on deference to the agency, not in that particular, but the idea, right, of deference to an agency. And certainly in, I guess, American Electric Power is where we saw that much more vividly. There's some sort of downside, right, to overturning Massachusetts versus EPA when it comes to climate regulation generally, because then you have to go back to AEP versus Connecticut and look at whether the federal government still has authority to regulate under the Clean Air Act. And if not, maybe the federal common law of nuisance comes back into play. But I agree with Dan. I don't see anything in this specific case to indicate danger to that particular decision.
Well, I'm certainly glad to hear that from both of you. We have a couple of questions in the chat and something that I wanted to ask you both about as well. which is the potential implications of this ruling, if any, for state level regulation of emissions. One reading would be that the decision essentially flips this sector in particular back to state authority. And that's an area that Justice Gorsuch highlights a bit in his major questions analysis on traditional areas of state regulatory authority, with California and other states leading on emission reduction efforts in their power sectors. Any sense that this ruling could have an effect either way on state efforts to regulate emissions? Dan, you seem to be shaking your head no.
I guess I would say no.
Okay.
Except to that legally, no. I don't think it has any effect. Except maybe you could interpret Gorsuch to actually support that idea. It has some practical impact. I think it's going to stimulate some states to do more. California imports a lot of electricity from other nearby states, and it probably would have been helpful to have more help from the federal government in cleaning up the grid in those states, but we're managing as it is. So I think I see very little either legal or practical impact.
Yeah, I mean, I think that's right. I think this may galvanize states to do more, even than they're already doing, but the states are already doing quite a bit when it comes to regulating emissions from the power sector, not just California, but even my recent home state of Colorado, which is traditionally a state that hosts a lot of coal-fired power production, a lot of coal mining, has taken major steps since 2010, at least, to start to shift away from coal-fired generation. And there are more than a dozen states now that have announced some kind of goal or target of carbon neutrality by mid-century from the power sector. So we are seeing aggressive action from the states. I think if anything, this decision will speed up some of that activity.
So moving to non-climate or non-emissions regulatory questions and looking at how the major questions doctrine could be extended in other environmental sectors. We've got some questions in the chat asking about the Waters of the United States rules, asking about the potential SEC moves on disclosure of climate-related risks, other areas that could potentially qualify as major questions in the very unclear state of the analysis. Maybe starting with you, Sharon, is there a particular rule that's in the proposal stage or a particular area of federal environmental regulation that you would be concerned about or that you think could have the same risk that the Section 111D regulations faced?
I think there are a lot of people going back over the statutes under which various agencies enact their programs right now and looking for danger zones and looking at possible risk for their agencies. I think the commenter was right on in identifying the Waters of the United States provision in the Clean Water Act and the jurisdictional test that'll be before the court in yet another Sackett case next term as one area of risk, right? It's a fairly broad provision, navigable waters, waters of the United States, right? How pervasive is the federal regulation under that scheme, and does that run afoul of the major questions doctrine as one area to look at? I think the SEC rules regarding climate disclosure are another. I've been following some of the listserv traffic with folks who know a lot more about this area than I do recently, with some people appearing to think that there's less risk there because looking at risks to businesses is squarely within the SEC's wheelhouse, regardless of the nature of those risks, so that there might be sort of less exposure there, but of course there are views on the other side. And I think another area that impacts energy regulation, but also of course environmental regulation more broadly, is this question of analyzing greenhouse gas impacts under the National Environmental Policy Act. So we've recently seen the Biden administration restoring some pre-existing regulations under that statute, which we affectionately call NEPA, which comes into play whenever the federal government takes an action that has a substantial impact on the human environment. It has to promulgate an environmental assessment or impact statement detailing those impacts. And one of the big questions there is, how much do agencies have to consider the climate impacts of their actions? And this is very important in energy policy, especially when it comes to infrastructure siting. So the siting of natural gas pipelines and related infrastructure. The DC Circuit has had a number of cases in recent years that have sort of hashed out, well, how much do you have to consider the greenhouse gas impacts upstream when you put in a new pipeline? Is that going to lead to increased extraction of natural gas, and what are the impacts there? Downstream, when you burn that natural gas, and there's a lot of uncertainty around exactly what that consideration looks like. Rules in that area might also be something that now fall within the major questions doctrine, depending on how it's interpreted.
Yeah, I mostly agree with that. In Sackett, the Waters of the United States case, it looks to me like from the CERT grant that the court isn't going to be looking at any regulation. It's just going to tell us what the Clean Water Act means. And so some of these same considerations may enter in. I don't know if the court feels that it's bound by the major question doctrine to have clear authority for what it's doing. And I think who knows what they're going to do, but probably they're going to cut back on federal jurisdiction, but how far, I don't know. I've seen some of the same discussions of the securities disclosure stuff as Sharon, and I agree with her assessment of that. In terms of NEPA itself, since NEPA is only a disclosure statute, as the Supreme Court understands it, it's kind of hard to see how that has, tremendous economic and political significance. And it seems to me it's pretty clearly within the statute, because whatever you might argue about climate change is clearly environmental. So I'm a little doubtful on that. I had thought about the issue with the Natural Gas Act in particular as well. And I think I don't know enough about the Natural Gas Act. So I'm going to defer to Sharon on that one.
Yeah, I mean, it's an interesting point about NEPA and its procedural nature, and whether or not you could ever characterize anything sort of done under the NEPA regulations as a major question. And there, maybe Chief Justice Roberts' formulation is actually more problematic for the agencies than Justice Gorsuch's formulation, because Chief Justice Roberts seems to focus less on the actual dollar impact of these regulations and more on the agency staying in its own lane, to use your phrase, Dan, right? Where, certainly greenhouse gases are environmental impacts. And certainly NEPA actually makes the environment every agency's business. That was the original intention. But I could theoretically see an argument, I suppose, that the calculation of the social cost of carbon, which the government does, of course, for agencies, and other climate impacts are so different from the traditional environmental impacts that agencies are used to assessing, that it's sort of a step beyond what they've been doing under NEPA already. I hope not. I hope that this is nothing. But we're in a position now where we're having to sort of rethink everything. I mean, I will point out, if you look back in time at some of the more transformative things that agencies have already done and then try to reassess them under this new rubric, you get a lot of sort of possible upsets, not to suggest that the court's going to go back and re-examine any of these, but the first thing that I thought about is FERC's essentially their single-handed transformation of the gas and electricity systems in the latter part of the last century, where they introduced wholesale competition into markets that were traditionally regulated, were monopolistic, and in Order 636 and Order 888, they fostered wholesale energy markets and competition in the sectors. I mean, talk about a transformative action that would be difficult to discern from that bare phrase, just and reasonable. That's the kind of action I'm not sure would survive challenge today.
Yeah, I think it partly, I thought of that same example. And in fact, there's a law review article by Jody Freeman comparing that with the Clean Power Plan, which really kind of sets up that question. But I suppose it depends on exactly what a clear statement is and how important it is, the sort of mouse hole part of it. Roberts ends the decision by saying that, this is the kind of big thing that can only be done by Congress or by an agency with clear authority from Congress. And so it sounds like if if we had a statute that said the same thing as 111D, only the heading was climate change regulation, that might have done it. And we just don't really know yet. So, I mean, we're really still trying to get a handle on just how activist this court's going to be, I think is the bottom line. I mean, they've been very activist this year, but they've had some long-standing agenda items on the conservative agenda, like abortion, that they've sort of ticked off. But after they get done with that, then what?
And of course, the really interesting sticking point with the major questions doctrine is its emphasis on clear statements from the legislature, which, I think, to be fair, the entire environmental community has been seeking on climate change for quite some time. The statutes, again, from Jody Freeman's article, these are old statutes and they're dealing with new problems. So that was a direct quote of the article's title, but it's true, right? These statutes have not been updated in decades. And that presents a real problem. If the court is cracking down on the agency's ability to adapt to new scenarios using the language of these old statutes, and Congress is unwilling to update those statutes or unable to update those statutes, you have a scenario in which very little is happening in terms of addressing the environmental challenges of today.
Yes, I agree. But let's hope that we can get Congress to take action, which we're going to have to do sooner or later, right? I mean, even under a very expansive view of the Clean Air Act, there are limits to what EPA can do. They can't impose, they can do certain kinds of regulations. They couldn't, for example, do a carbon tax. They probably, there are limits, and we really need Congress to take a hand.
So, building off of that last point, Dan, a couple of the participants have raised questions around what other avenues might be available if effective regulation under Section 111D is now off limits. And they've raised Section 115 of the Clean Air Act, which deals with compliance with international agreements and has been flagged many times in the past, as well as provisions under the Toxic Substances Control Act, recently amended, which have been thrown about a bit in the last couple of weeks. I'm curious if either of you has a thought on the ability of the agency to take effective steps under either of those provisions, or if there are any other provisions that might step forward for this particular sector.
My view is that the court's not going to like any of those ideas any better, and maybe worse. So I just don't think, I could be wrong. I'd be nice to be wrong, but I really don't see any likelihood there. I think the alternative in some ways is to just press hard in terms of regulating conventional pollution from power plants. And I think there's a justifiable basis for doing that, even apart from climate change. But just from the point of view of climate change, just sort of tightening the screws economically a bit more.
Yeah, I think that's right. I mean, I think using TSCA and to a lesser extent, perhaps using Section 115, we're certainly going to see similar challenges. It may be worth trying, and I don't know what EPA is considering right now. I'm sure they have lots of ideas. Maybe even a NAAQS for carbon dioxide, which is something that the agency has not been interested in pursuing for a long time, because there are some challenges with the statutory language there, and certainly for state compliance with a national ambient air quality standard. But it's not out of the question. One interesting possibility is to continue to use Section 111D, but to select as the best system of emissions reduction a technology that can be applied right at the plant itself, and which is a technology that has been pushed by the fossil fuel power industry for a long time, which is carbon capture and sequestration. Now, EPA did select partial carbon capture and sequestration as the best system of emissions reduction in its standards for new power plants under Section 111B in its new source performance standards, but not for existing sources. Now, the pushback there is the question of whether CCS is adequately demonstrated. Do we have enough demonstration of carbon capture? But interestingly enough, even though the only US plant, the Petronova plant that was using carbon capture is no longer doing so, we have several plants that are coming online that will be using carbon capture and sequestration. And if you look at a lot of the statements from the industry, they are very bullish on the prospect of carbon capture and sequestration. So to the extent it becomes possible to use that as the BSER for 111D, that would produce a high level of emissions reduction.
Yep.
And of course, highlights the point that EPA, in an effort to find an adequately demonstrated set of technologies, but also a cost-effective one, and in picking the measures that the utility industry itself was following, and as evidenced by their participation in the case on the side of EPA, have been able to follow, in effect, tied their hands with regard to this court's interpretations, because they selected a more flexible set of measures, and perhaps a more restrictive set of measures might be viable under the Supreme Court's analysis, even if it's less economically efficient to implement.
And of course, the beauty of 111D, and one of the reasons that it actually is quite appealing to industry to use that section to regulate existing plant emissions, is because once EPA sets the standard for emissions limitations using the BSER, the states can do anything they want to achieve that goal, right? Or they have a much broader array anyway of mechanisms and strategies and technologies that they can require to get to that standard. So it provides the states with a lot of flexibility to choose a quite efficient, cost-effective method to achieve those limitations, and that's to industry's advantage.
Yeah, I think that's an aspect of 111D that just got lost along the way. The court talks as if EPA was going to directly impose a solution on the industry, whereas there is this sort of mediating role of the states that could change the way that it's implemented.
And we haven't talked much yet about Justice Kagan's dissent, but one of the characteristics, I think, of Justice Kagan's writing in the Clean Air Act space and environmental regulation generally, and sort of her opinions more generally, is that she engages with the nitty-gritty details. So she immerses herself in the dissent, in the language of the statute, in the context of the statute and the purpose of the statute in ways that the other opinions don't. I mean, Justice Gorsuch is pretty clear he's not going to do that. He's going to leave it to the majority. The majority, as Justice Kagan points out, doesn't get to statutory interpretation until the last, page 28 of 31, I think. And so Justice Kagan is doing this very almost Scalia-esque interpretation of the statutory language, where she talks about this section 111D and understanding what system means in the context of this section and what it was supposed to accomplish, taking into account some of the factors that we've just been discussing, the flexibility inherent in the provision. And so, I think that to a much greater extent than the other opinions, Justice Kagan is doing a very, she's sort of staking out her claim as almost the new textualist on the court, but also one that tries to understand this provision of the Clean Air Act, what it was designed to do.
Yeah, that's actually my biggest maybe criticism of the majority, is I don't think the majority opinion really actually tries to figure out what EPA is doing and how they're doing it and why. They, everything they say about the case, you could almost get from an op-ed about the statute. It really, there really is no effort to dive into those details. And I think Kagan's right. That's one of the real vices of calling this a separate doctrine, instead of just viewing these considerations as relevant to statutory interpretation, and then reading the text and thinking about these things too, and trying to figure out the best interpretation of the law.
And I think Justice Kagan had an invitation here to Chief Justice Roberts and maybe anyone else that was willing to join, to transform the major questions doctrine from sort of this overarching inquiry that precedes either step of Chevron deference, right, which normally precedes, the court says, is the statute ambiguous, and if so, is the agency's interpretation reasonable? The major questions doctrine, as articulated in this case, seems to sweep all of that away and stay at this almost step zero stage, where they're just asking, is this an elephant? Is this a mouse hole? And if so, it's off the table. Whereas I think Justice Kagan's invitation was, make this part of ordinary statutory interpretation. as the so-called major question cases you cite in the past have done, right? Consider it as part of this analysis. Is this an ambiguous provision, right? And is there, if so, is there room for this interpretation? Why create something new? Why not just use the system that we've already established, which would require deeper engagement with the statute in each case?
So we've only got a few more minutes left. We've had a tremendous number of excellent questions from the audience. I want to pull one more final question from the audience, and then we'll conclude with some quick closing statements from both of you. One of our commenters has pointed out, as we discussed a bit, and Dan, you mentioned this in the context of the cert grant in the Waters of the United States case. Any concerns about the court's approach to standing in this case and their willingness to take and review an appeal that was of a regulation that never went into effect, and to essentially preempt an agency's decision prior to the agency actually announcing what that decision might be? Do you see any implications for environmental or other areas of regulation in the coming years?
I'll just say quickly that I think it's part of a general tendency for the court not to wait for the process to play out. We see this on the shadow docket all the time. We saw it with the stay order in the Clean Power Act case in 2015, which was completely unnecessary because the only thing that was going to happen was that states were going to start planning. Nothing would ever actually happen to the power industry until several years later. And I think this sort of eagerness to introject itself into big legal controversies it is, both for practical reasons and sort of jurisprudential reasons, really a bad sign.
Yeah, I certainly could not have said that better.
And actually, Dan, you point out in the context of a court in a hurry to reach these cases, one of the NGO lead counsels in the case had some tweets this morning pointing out that they actually completely overlooked the nature of one of the standing claims of one of the coal parties to the case, and that they actually did not fundamentally had not established standing in terms of their the nature of their appeal to the Affordable Clean Energy Plan in the court below, and the court disregarded that because they were in a rush to get the opinion out. So we've got just a couple of minutes left here, and I'd love for each of you, starting with Dan and then Sharon, a closing statement, final thoughts on a key takeaway final key takeaway from either that we've discussed that you want to reinforce, or something that we have not yet discussed that you would like the audience to draw from this conversation and from last week's decision by the court. Key considerations for the future and for the next term. So we'll start with Dan.
I really didn't think that EPA had a chance of winning this case. From the moment, I think when Obama was unable to get Garland onto the Supreme Court, that was, pretty much the end of a real hope that the Clean Power Plan would be upheld. So I'm not shocked by the outcome in this case. I obviously would have preferred an even narrower holding, one that just looked at the text of the statute and did, even if they weren't right. I don't like the major questions doctrine. I do think that, I hope that the opinion gives the major questions doctrine and its application to EPA in particular a little more concreteness in a way that will allow lawyers to actually work within the doctrine and find ways to get things done. So from that point of view, even if it's a bad rule, I'd rather know what the rule is than have them completely just make things up as they go along. But I think it's even more important for states and for the private sector to take action because we know the federal government they're never going to catch up to California. And we can't afford to wait for them to get there.
Yeah, I mean, I tend to think about this case in terms of the way that it affects both agencies and the public generally and those outside agencies. So, for agencies, if I'm sitting at EPA right now, if I'm sitting at FERC right now, I would very much be wanting to dot my I's and cross my T's when I'm promulgating new regulations. I would be wanting to proceed somewhat incrementally. This is not a time, I think, to test big transformative moves because of what this court will do with them. So I think this is a time for collaboration. This is a time for collaboration between the federal agencies and their state counterparts. This is a time for collaboration between state agencies and regional entities. A time for collaboration between states and local governments and potentially partners in other countries. It's a time to get creative unless and until we have big pieces of federal legislation that answer these questions one way or the other. And to give the most charitable reading to opinions like the one from Justice Gorsuch and concurrence in this case, and even to Chief Justice Roberts' majority opinion, the court is asking Congress to do its job. And so we need for that to happen. I think that's become increasingly clear across any number of areas, and this case is doubling down. To the extent that the Supreme Court is skeptical about what agencies can achieve under the statutes they have, we need new statutes.
Great. Well, thank you so much, Dan, Sharon, and Ted, for sharing all of your expertise with us. It was wonderful and excellent moderating, Ted. Thank you to everyone who attended for all the excellent questions. Really appreciate all of that input. Thank you also again to our partners, Sonsini, Orrick, and Hanson Bridgett for making this possible, and invite all of you to attend future Lunch and Learns. Our next is later this month, where we will discuss the preservation of the Coyote Valley down near San Jose. So would love to have folks join us then on July 26th. So thank you so much, everyone, and we'll see you soon.
Thanks, everyone.